Hello, everybody. Thank you for joining us for our new edition of Condo Insider. So for some of you that might not be aware that Think Tech is retiring. So we have found and created, recreating what we were doing before with Condo Insider, but we now have a new producer and we have our own YouTube channel that we're going to be building on. So for this first segment for this show, we are going to talk about employment law and basically hostile work environment and also employee harassment, because I've been getting a lot of questions about it through emails, and it's been coming up in discussion where that line stops as far as, as an owner or board member, who really can talk to the employees when they're out doing their work. I know as a condo owner, sometimes you run into the maintenance guy, you're like, hi, how's it going? What's up? And then you start into a conversation. Or, sometimes it might be some people, and I've seen it happen where some people are directing the worker on how to do certain things, which it really is not cool. So we're going to start off with John. So John, explain to us what the definition of employee harassment is.
Employees often use the term harassment to refer to a wide range of behaviors, and it could be anything from constantly reminding them to do their job well to insulting them based on their race or sex or some other protected category. The law prohibits discrimination against employees based on protected categories like race, ethnicity, national origin, age, gender identity, sexual orientation, you name it. Assume everything is protected and every employee has some protected category. So if a homeowner or a board member or even a third party makes comments to an employee that have some reference to a protected category, that could constitute harassment if it's either frequent enough or severe enough under the law. And so our state law would apply to every employer with one or more employees that prohibit that behavior. And federal law would apply to those associations that have 15 or more employees. But very, very quickly, the employer has an obligation to remedy any observed, known, or should have known conduct that would be of a harassment nature. So once the employer knows, whether that's the resident manager, whether it's a board member, whether it's some supervisor, if they're aware of conduct that is infused with some kind of bias that would be a violation of our laws, then we have an obligation to investigate, correct it, and take reasonable action to stop it. So that's the legal side of it. But there's also just the generalized kind of harassment that my boss is mean to me. The homeowners are nagging me about cutting the bushes in front of their window or something. That's not illegal, but it can lead to legal liability. And where I recommend associations deal with this is in their bylaws. Not in their house rules and policies. So I think it's important to remember that the person that's directing the work of your employees is your resident or general manager and those supervisors, not homeowners. So homeowners have to be made aware they're not to interfere with the work employees are doing. And so a house rule that addresses that, in addition, says don't harass, intimidate, use improper language towards our employees, and use your house rules to enforce that behavior. Because even if it's not discriminatory on a protected basis, it could lead to stress claims. It could lead to emotional distress. And then you have a workers' comp claim, you have leave of absence issues, you have a potential, like I said, workers' comp claim, or even a disability claim where somebody says, oh, I can't take it anymore, I'm going out on leave. And then they're on leave for several months talking to a psychiatrist or a counselor, and you're struggling with trying to keep everything under control in the property when they're protected under disability law. So in overall, that's kind of where I see these issues. There's a potential, if the harassment is severe enough, to raise issues of safety that could lead to a HIOSH issue of not protecting employees and maintaining a safe work environment from known hazards like an irate homeowner or a difficult resident in any event, or board member for that matter. So that's kind of the summary of everything.
Yeah, so it would apply to everybody from the managing agent, general manager, resident manager, site manager, down to the homeowners, and even their occupants.
The law protects employees from harassment by anyone, and so whether the harassment is by a coworker, by a supervisor or manager, or by a third party, and that includes homeowners, contractors, guests, residents, renters, you name it, or members of the public that happen to be around the property.
So Taylor, how would as an attorney, condo attorney, how would you handle the situation to protect your condo associations that you represent?
Yeah, John hit the nail on the head. Implementing something in your house rules, something that has teeth, that can prevent an owner and or the owner's guests, tenants, occupants from unduly harassing an employee. That way, after your first initial fining letter, you can then institute additional fines and or even pursue legal action to make sure that you protect your employees. Because a lot of times these owners don't realize that the board is the employer, right? The board is managing the affairs of the corporation, which is the association, most of the time the nonprofit corporation. And if they don't do anything, and as John alluded to, the board can be condoning these acts by not notifying the owners to stop this behavior. If there's something in the house rules, which are distributed to everyone, and it should be distributed to the owner's guests, at least they have notice that there's proper procedures. The board of directors is the one, and the resident manager or the general manager is the one that should be providing direction, and not the owners, and that their conduct could be deemed to be harassing if it's a persistent critique of the employee's work or just criticism or attacks based on a protected class.
One of the things we also talked about between you and I, Taylor, was the chain of command. So the house rules would have to really dictate that chain of command, right?
Yeah, and that's always a great idea too, is implementing a chain of command. And that goes for directors as well. A lot of directors, when they get elected, they think that they're now in charge all the time. And they're only a director at a board meeting. So a lot of times directors feel very accomplished when they get elected from their cohorts, and they'll then go and try to boss everyone around and try to make the property unique to their needs. And that's not how it works. It's a democracy. The board needs to vote on the direction they provide their employees. And that chain of command kind of helps directors learn that and understand that the board needs to proceed, and the president or the property manager provides that direction to the general manager and the employees.
I have a question for
one of
Taylor.
the big. Oh, I'm sorry. So one of the big things that everybody has to remember is that as a board member, you're only a board member during that time that you're in a board meeting. Outside of the environment, you are just a homeowner like everybody else in the building, right? Okay, John, I'm sorry to interrupt you.
Yeah, Taylor, what can associations do in their bylaws to give them some teeth to enforce the house rules like this? So interfering with employees in their work or being harassing or discriminatory. And then if they don't respond to whatever steps you can take within the authority of the board, I think there's options to get TROs and things like that. You might want to comment.
Yeah, exactly. So usually the bylaws provide for a fining mechanism, right? They can implement rules and they can implement whatever necessary steps there are that the board deems necessary to manage those rules and to enforce those rules. If they don't, there are procedures within 514B, if you're a condo, that allows the board to implement house rules if their bylaws are silent. But there has to be an appeal procedure, which we recommend anyways for due process. So if their bylaws allow for fining procedures, the house rules can implement. no harassment of employees, can direct owners to look at the code of conduct, or not the code of conduct, but the chain of command policies that the association should adopt. And then if an owner is if someone reports an owner to be harassing an employee, then you can institute the fines that are elaborated in the house rules. And then two, a lot of the times we will, if it's so egregious and it needs immediate rectification, we'll represent an owner or we'll represent an employee and pursue a TRO on behalf of that employee.
Wow.
In the association. Yeah, so TROs are only unique to the employee. So the association can't file a TRO against a harassing owner, but it can do so on behalf of the employee. So the employee can have a TRO, and at that point, the association can assess those costs to the harassing owner if it's in their house rules, because it's a violation of a governing document, and all the attorney's fees for that violation can be assessed.
Thankfully, there are few instances of rogue directors that won't behave and engage in behaviors outside of board meetings that are, interfering with employees' work or harassing them in some way. Can the boards remove a director?
It's incredibly difficult. It's incredibly difficult. It has to be the exact same procedure to which the director was elected. The same amount of votes usually are required of the ownership to remove that director. There are, in extreme situations, a judicial remedy. You can petition the court to remove a director if they're participating in fraudulent conduct or conduct that is detrimental to the association that could result in immediate liability. But that's extreme situations. I've only seen that happen once and petitioned for it a few times and have gotten rejected because it is such a high standard. But then that's what's very helpful with having a chain of command and a code of conduct policy is to try to assist. Directors are so strong-willed a lot of times that they think that they're doing what's right for the community, when in fact it's very detrimental and it incurs attorney's fees and costs to try to make everything right within the association and the board. But hopefully cooler heads will prevail and they'll move on and do the right thing.
I'm going to put a little gloss on this because the discrimination laws require the employer to take every reasonable step, every action that is reasonably calculated to prevent the harassment from recurring. So, if somebody's not responding to a cease and desist letter, you've got to take the next step. If they're not responding to the next step, you've got to go to the next step. And so the courts look at this and say, well, the person told you they don't believe you have authority to tell them they can't do that. Right then and there, you have to up the discipline or the action to try to get control of that behavior, because you could be sued for not taking effective remedial action. And that's just as bad as being the harasser yourself.
That's a great point. That's a great point, because a lot of times directors, as you alluded to, it's so hard to remove a director. And what we recommend is if the ownership isn't willing to remove that director, you have to just paper trail it and provide censure letters and make sure you have a record that you've tried everything to contain this rogue director, and just hope that the court finds that to be sufficient. Since it is a diplomatic process, it's hard to remove someone that is elected by the ownership.
And when we talk about discrimination law, harassment based on a protected category, our state law is a lot more strict than federal law, in that if it's a supervisor or manager that engages in the harassment that creates a hostile work environment, there is no defense. Once you cross that line, once somebody with authority over an employee's working conditions crosses that line, you have no defense. It's get the checkbook out, pay them the damages and emotional distress they incurred from being harassed on the basis of protected category. So where this gets complicated is with directors who engage in behaviors outside of board meetings that either get condoned or ratified by inaction of a board. And then you have absolute liability. So every time the director acts in an inappropriate way out there that could create liability, the board has to distance itself from that conduct by disclaiming or, saying we disavow any authority, any action that this person took where, that wasn't us, and we do not condone that behavior, and we're taking actions to prevent it from happening.
Well, if Savio was here, she'd be kind of going off on a little bit because besides the legal part, you have the insurance part of it.
Well, and this is becoming an issue too for a lot of associations, and Taylor probably knows this as well. Different carriers are very picky about when you notify them of a potential claim. So if there is a complaint made by somebody of harassment, that may trigger your duty to notify your carrier immediately that there's a potential legal claim. And if you don't notify them right away, then they may deny coverage later on when you get sued.
Exactly. And not to harp on this chain of command and code of conduct, but it's good to have that implemented when new directors are elected so they can be educated, because time and time again, these directors will act outside of a board meeting. They'll make inappropriate comments outside of a board meeting. And a lot of times with agency principals, that can be deemed to be apparent authority. And if the board doesn't know about that and it spirals out of control, you could really be behind the eight ball. And then you're dealing with John and myself trying to rectify the situation, when if there was proper education at the very beginning of this, they would know not to do these kinds of things and to respect the process and make sure that all discussions are made in a board meeting and not outside of one.
And Taylor, I'm sure you probably will echo this, and not by email or text message to the employees.
Yes.
Because many of the cases that we deal with, there are tons of text messages to the employee from some board member or emails to that employee at 3:00 in the morning when the board member is stewing and can't sleep and has to let loose in some tirade against them. And that's the worst kind of situation. So
put down the keyboard.
Close your computer down at night and do not do that.
Sleep on it.
Yes. Bring it up in executive session the next day.
Yep.
So one of the things that I think crossed my mind in talking out this topic was sometimes owners think they're doing their best efforts, or they think they're helping, like especially the landscaping. Everybody has an opinion on how a plant needs to be trimmed, and there was one where this one lady really liked to see out her window. So she didn't like the plants to grow where she couldn't see out the window. But the groundskeeper kept telling her, no, and so he kept doing his job because that was the protocol that the board had established and how the plants are supposed to be maintained. And so she felt unheard, and so it just kind of built because she really felt that she was being unheard. And it got to a point where she just kind of like blew up. But then a neighbor of hers finally took her aside and said, do you realize why they keep the plants at that height? And she's like, they finally got her into a quiet point, but they had to explain to her they do it that way because they discovered that if they don't keep the plants that way, people take the opportunity to look in the window. Even through the plants, if they thin it out a bit, especially at night, you can see right through the window. And so this neighbor had said, are you aware of that? And she was totally shocked. So she kind of after that, she stopped, but it comes to that, because she's a new owner. So she didn't know the history from before as to the reasons why. And the gardener didn't really want to tell her because sometimes, may not have been his place either for him to say it. He may not have known the reasons why, the background of it either. But, I kind of try to tell people, I go, sometimes you have to kind of figure out the whys that they do it that way. And it could be related to how the plant grows, to grow bushy. So you trim it a certain way, so don't just be barking up a storm until you kind of try to figure out the reasons why. Maybe that's why it's being maintained in a certain way,
Another aspect of this, Taylor would probably recalls this case. There was I believe it was a Maui case years ago, where one of the board members would follow the employee around, watching them do their job and criticizing them. And eventually that employee sued for emotional distress and harassment, just generalized harassment, because the board member really, as Taylor mentioned, doesn't have any authority to do that. And despite their complaints, they sued, and my recollection is there was a finding in favor of the employee.
Wow, that's severe. I mean, for a board member to go that bad, I mean, that's really severe.
Yeah. Well, yeah. If I'm sure, Raylene, you've heard the cases where board members stand around and take pictures of employees when they're supposedly working or not working, or how they're doing things, and then put them on the internet and complain that employees aren't doing their job. Then there's other issues there. Taking those kinds of actions into your own hand as a board member outside of an official board meeting is highly dangerous. It could lead to libel. It could lead to, all kinds of claims.
Yeah, in regards to your example, Raylene, I don't want to make it seem so militant that owners aren't allowed to talk to the employees, right? Associations are such a dynamic animal. There's so many moving pieces, and Hawaii is a pretty friendly state, so that everybody probably is just all looking out for the best interests of the community. So owners talking to employees, I have no problem with. It's just make sure to closely monitor and make sure it doesn't get out of hand. Ask employees to have evaluations with their supervisors, so that things that are at the very infancy can be discussed and can be nipped in the bud before it gets to something egregious when it's too late. But it's always better. I would always recommend that let the board of directors, let the general manager do their jobs by supervising the employees. The board, if you have concerns about how an employee is doing their job, the proper forum is an open forum in a board meeting. And if the board is doing their job, in which they have a fiduciary duty to make sure that owners' concerns are listened to, and that if there is an issue with landscaping or how an employee is cleaning certain areas of the project, that they be addressed. So I don't want to make it sound like they're not allowed to talk to people, but we just want to make sure that everybody lives in harmony.
And if you have the house rule that Taylor recommends, you can always remind a homeowner that there's a rule of civility in how we talk to employees, and you avoid subjects that are sensitive to employees.
Right, because your homeowners are your eyes and ears as well. And this conversation shouldn't prevent an owner from raising a concern that they see. Like they could probably see something that is leading to a frequently watered area where the water hits the wall, is leading to wood rot, like bring it to the board's attention. And it could be sometimes wood rot or even termites. Sometimes you don't even know it. I remember being in a resident manager's unit because we're looking at what needed to be worked on to renovate the unit. And I touched the door trim, and it was all hollow. It was only the paint. The skin of the paint was there. So we all started laughing. We're like, oh my God, we're like, so sometimes you get used to seeing how termites, when you really are in that termite business, you can kind of spot potential areas, So if an owner, it's kind of like knows that kind of stuff, I mean, they shouldn't be prevented from, but they still got to go through the chain of command saying, hey, we noticed this, you guys might want to take a look at it, because it doesn't look right, might be a potential, but again, it's really following the chain of command and bringing it to the board's attention. It's another story if you bring it to the board's attention and 6 months later, it doesn't seem like anything's being done, what would be the next step?
Well, you could raise that at the next annual meeting. Try to get a new board of directors that are a little bit more attentive to the owner's needs. Worst case scenario, you could always file derivative action on behalf of the association against the board. Most likely that wouldn't result in anything because of this minor issues at hand. But AOAOs are like small governments, right? It's a diplomatic process. And it's just like any of your elected officials. If they're not fixing potholes, what do? You vote for the guy that claims he's going to fix potholes. So that's what you can do at your next annual meeting.
And a good point, the annual meeting is going to be, the board will be presenting their the goals for the next year, so that repair item could be on their agenda. May look like no action, but behind the scenes, there could be work being done. It just needs to be disseminated correctly. So that everybody knows what's happening with certain things. So we're hitting at the 20-minute mark, but I wanted to take a couple seconds to do a little mini advertisement. So Hawaii Council has our Board of Director training coming up in July, the 13th and 20th. John Knorek is going to be one of the speakers, as well as Taylor. So we encourage everybody to go online and register. It's 2 days, part 1 and part 2. We are also creating a part 3. The part 3 will be all on financials. That's going to be our October seminar. It's about 4 hours of just going through the financial documents, how to read them, how to make sure that all the numbers match where they're supposed to match, potentials, fraud, how to spot fraud. Because it's so easy to take certain documents and import them into the right software, and they can be manipulated and reprinted out. And some people would never even know the difference. So we encourage everybody to go online, register at hawaiicouncil.org, and it has all of our future seminars on there. So John and Taylor, I really want to thank you for being here today on our first own Condo Insider. This was great. And I hope it's going to help to answer a lot of questions related to employment for our condos, because we do get quite a few of them coming in. There was one the other day, and I go, you need to consult your condo association attorney first. I go, we're not here to give legal advice. That's your first stop.
Thank you, Raylene. I appreciate the opportunity to be here, and hope what we had to say was helpful. And thank you, Taylor, for being there with us.
Very helpful. We'll see you guys in July in person. Thank you.
Mahalo.